started soon. If you'd please silence any technology that we do at this time. All rise. The Court of Appeals Division 1 is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in Carr versus Gates. However, the real party in interest is the state of Arizona. Let's begin with introductions of counsel for the petitioner.
Cynthia Brubaker here from Ralph Carr. And Rebecca Feldman here from Ralph Carr.
Thank you very much.
Good morning. Karen Kemper for the state.
Very good. Thank you very much. Let me go through a few preliminaries that you may be aware of, but just so that we're all on the same page. Let me first advise the parties that we have reviewed carefully the materials that you have filed with us and portions of the record as pertinent to the issue today. I believe that we set this for each side having 20 minutes. I think that's what we said. And I raised that because a lot of times we have a default rule of 15 minutes, but we set this for 20. The petitioner may reserve time for rebuttal. When you go to the podium, if you'd like to reserve time for rebuttal, I would suggest you let us know, and we'll do our best to honor that request and not ask you too many questions. We are recording these proceedings today, both audio and video. And so when you go to the podium, if you could please restate your name both in the opening and the respondent's argument as well as in the reply. That way, if we have any members of the public who are listening, they'll know who you are. I think those are the basic preliminaries. So with that, let's go ahead and begin.
Good morning. I'm Cynthia Brubaker here for the petitioner. And I just want to say that we're here because we have questions for the parents of two of the actual alleged victims in this matter, and that we believe that the questions that we have for the parents that we need to ask during an interviewing process are questions that we believe are within the scope of the JD case. And we are not trying to go beyond that scope. We are not trying to ask questions to get around or do an end run around victims' rights as to the actual victims who who have alleged harm caused allegedly by Mr. Carr. We are not trying to do an interview to obtain information as to information that or any confidential statements made by the actual victims to their parents. That's not our focus or our concern. And in our petition for special action, we have listed, I think, approximately 20 to 22 different types of topics. And I think the majority of those topics of questions that we would want to ask the parents at a pretrial defense interview that we've not been permitted to do so far, even though the actual victims are now no longer minor children, they're adults. That list was kind of in the form of an offer of proof, list many questions or many topics and areas, and we believe that the majority of those areas do not involve getting into the area that that victims' rights would cover for a victim, and getting into and asking questions or inquiring or exploring into areas that would be information that the minor children would have told their parents. Again, I want to emphasize that we're not.
Go ahead.
Counsel, I was just curious, why should this case necessarily kind of move to the front of the line rather than waiting for an appeal? Isn't this an issue that can be raised on appeal?
But by that point, it'd be too late. We have issues that we need to question the parents about.
But isn't that something that you would raise on appeal? And if you're right, if Heggie is the way the court comes out, then don't you have an issue you prevail on, or at least you have a chance of prevailing if you show prejudice? It arose in Lucas in the context of a direct appeal, correct?
I believe so.
So why couldn't the issue be addressed after trial with any other issues that come up?
Because, well, we would have gone through the whole trial.
But isn't that the same that can be said for any?
I guess I don't have a whole lot of faith in things being resolved through the appellate process. I think I would like to get it done right at the trial process. I'm sorry, I don't mean to be offensive in any way by saying that, but I think that that Mr. Carr has a constitutional right, due process rights, to be able to obtain a ruling now before he goes to trial, and I think there's time to do that. And I don't think it would cause any prejudice to anyone, and I think it would be definitely would be beneficial to Mr. Carr, and would enable Ms. Felmy and myself to better represent him if we were able to get a decision as to this matter and know right now whether we're going to be able to ask the parents the questions we want to ask, and it would also impact on our defense, the direction that our defense would take too at trial.
Let me go back to what you had called the offer of proof. Let's assume for the moment that what my colleague here has called the Heggie case, which is actually, I think, probably the JD case. There's limits on, even under that case, assuming that is the controlling law of what the defense can ask. And I look at your petition at the offer of proof at page 11. I'm really hard-pressed to see how it is you're staying within the confines of the JD case, because it appears to me that what you're attempting to do is wanting to inquire about communications that occurred between this particular victim and this victim's parents. And I think that's off limits.
And I agree. I think it is off limits.
Okay, so then tell me what it is, where the offer of proof is of what you're entitled to ask.
Well, I think that we would be able to ask questions, for example, whether the parents, whether there's any collusion between the parents of one of the actual victims versus the parents of the other actual victim in the case, to see if there was any actual, as I said, collusion. I don't know how else to say it. Any kind of collaboration or collusion between the parents, as
well, even that may well, depending on your timing, run afoul. You had that opportunity to ask those issues when this case was first tried, didn't you? Or Mr. Carr?
In a very, very limited degree. That was in front of a jury. The jury was there. We have to, of course, be very careful what kind of questions we ask. We're always hesitant to ask questions that we don't know the answers of.
Well, that's true for every lawyer in every single case when you go to trial. But what you're asking, it seems to me, as I read this, you're talking about the parents' credibility. And the reasons for what you assert is a false accusation. I mean, I look at that, and you keep in mind, I was on the panel in the JD case, so I'm familiar with this. But I'm having a hard time understanding what you can ask even under the JD case.
Well, I think we could ask if one of the parents has indicated that he wanted to file a lawsuit against Mr. Carr. I think we could ask the parents we would like to inquire more about that. And that same parent also had received information about Mr. Carr prior to bringing these charges that was derogatory information. We would like to know about that. We've never been able to ask questions about that. And waiting until trial to ask that questions, it's not only extremely dangerous, but it also doesn't give us time to do any follow-up on any of the answers we would have gotten at trial. You can't follow up in the middle of a trial.
Did you know these issues before the trial in the 2011 case?
The majority of them.
So
there are some additional things that have happened since then, but most of them.
Okay, so you could have made inquiry, I guess, although at risk in the cross-examination. That's what you're really saying.
We asked as many questions as we could, as we felt safe to do so. But there are some additional questions that we didn't feel comfortable asking all of the questions that we would like to have asked.
So let me ask you a procedural question. After the mistrial in 2011 case, the state elected to dismiss the 2011 case, and then the 2012 case, it refiled the 2012 case. And I understand that one of the victims turned 18. Am I right on this? Before the 2012 case was refiled or was filed?
Turned, you mean in terms of?
She became 18.
Oh, right, turned 18. Sure.
Okay.
Well, let me make sure I understood your question. Yeah, one of the victims had turned. They're both 18 now.
Right.
One we believe turned 18 before the case was reindicted, and then one turned 18 after.
Let's talk about the victim who turned 18 before the case was refiled, based on the indictment, which was in. Actually, it was December 17, 2012. So I want to be clear. One of the victims turned 18 during the pendency of the 2011 case, but before the 2012 case was filed, or the indictment. Mm-hmm. Okay. At that point, if I understood your argument, it is that the statutory rights are no longer applicable because the parents do not now have the right under the Victims' Bill of Rights statute to act for their child or their daughter because she's now reached the age of majority, right?
Right.
And that's because we now have a new lawsuit. Did you raise that argument in the trial court? Is that argument properly preserved here?
I don't think so. I don't think I did.
You don't think you raised it?
I don't think that particular argument, in terms of when the victim's rights for the parents when they would need to assert them, they would need to reassert them for the new, is that kind of what you're getting at?
Yeah, assuming Lucas
I don't think I raised that.
and I apologize for interrupting, but
Sure.
assuming Lucas is the law. So you didn't say, even assuming Lucas is right, as to this victim, there's a new indictment, and even under Lucas, the parents were entitled to interview the parents even under Lucas. So that wasn't raised.
I don't think, honestly, I don't think I thought of it till I was preparing the special action. I wish I had thought of it sooner, but I didn't.
But that does create a problem for us.
I see your point, yes. But I don't think that that's insurmountable. I mean, I think the controlling issue is that these parents don't have they no longer have, with the minor actual victim turning 18, I don't think they no longer have any rights to assert victims' rights. I think, and again, I'm relying on JD for that. I think that they no longer, if the minor is not, if the victim is not a minor anymore, then we have a parent that no longer has the rights.
If I could just ask, and that's true if JD is the law, but assuming Lucas is the law, I mean, would you still have an opportunity, were we to decline jurisdiction, would you have an opportunity to go back into the trial court and say, we're entitled to interview the parents of this other victim because the new indictment restarted the clock? Is there something that would prevent you from doing that?
No, and you're correct. We could do that, and that's what if you did decline jurisdiction, that's exactly what I would do. That'd be my next step.
Let me raise an additional question, and it really relates to the practicalities of the situation. And this is rather unusual, I think. We have two cases from the Arizona Court of Appeals that reached conflicting results. The Arizona Supreme Court has accepted review on one of them, but obviously when the court decides that matter, it will decide for both of them. Okay. This case is currently set for trial, although it's now currently stayed, for early September. Why not work out an arrangement with the state to have trials stayed until after the Supreme Court issues a decision in the JD case? Then everyone has clarity, and we all know the state of the law.
I think that's a great solution, and I've actually thought of the same thing, because I'm aware of the pending cases in the
Right.
Supreme Court, so I had the same thought, too.
And did you request a stay in the trial court pending resolution of JD, or just pending resolution of this proceeding?
Pending, well, because when I asked for this day, I didn't know I was even going to be lucky enough to be able to appear in front of you today. So I was just asking to stay the trial proceeding so that we could resolve the obvious conflict between the two cases. Here, I had no idea that the cases had gone on, either of them had made their way to the Supreme Court. I hope I answered your question with that.
As I understood your answer is that you had requested, you had requested the stay because of the conflict within the Court of Appeals. Well, that conflict hasn't gone away. You're still presented with it. Okay.
Right, and that's correct. And I was wondering too what we do with the fact that we have that case, and maybe both cases eventually, I guess, up in the Supreme Court. And it seemed to me that we really need a decision from the Supreme Court, ultimately.
Well, they're going to decide the issue here, I think it's fair to say.
Because I think whatever happens here, somebody's going to be appealing it probably up to the Supreme Court, right? Either whatever the decision is, possibly. So, anyway, I think I have made pretty much all the points I need to make. I would just like to reserve whatever time I have left for rebuttal, if I could. Thank you.
Good morning, Your Honors. Karen Kemper, appearing for the real party and interests of the state of Arizona. This case is really about victims confiding in their parents, parents having a right not to be interviewed, and a trial judge who followed the law. It's the state's position that following Lucas was not and could not be an abuse of discretion, where Lucas was a decided case, on point, and it satisfied all the policy considerations that surround victims' rights. Frankly, based on the questions that were asked of the petitioner, the state did request that this court decline jurisdiction and wait until, and forgive me for having referred to it as the Hagee case in the pleadings, the JD case, until that's resolved. However, as this court was discussing that with the...
I'm sorry, are you saying you ask us to wait, or?
Correct. That because that case was pending, the JD case, before the Arizona Supreme Court, to hold this in abeyance or to decline jurisdiction until the resolution.
But if we were to decline jurisdiction, what would be your position in the trial court? Is it your view that the trial should be stayed pending resolution of JD?
And that's a more difficult question, because how can the state stand here today and say to you that all victims' rights are important, and of course the right to justice and resolution, in a case that has been pending since 2009? It would be disingenuous to suggest that we would be in favor of staying this any longer. These girls were young girls at the time of the offense, 12 and 13 years of age. You've heard that they have reached majority, but this case was pending all during their high school years.
Let me go back then to what you're asking us. Are you asking us to decline jurisdiction, or to accept jurisdiction but hold off on ruling until the JD case is decided?
And it would take, I would need to be a lot more educated to know if that's a distinction without a difference at this point, or if it's a distinction with a real difference.
Well, if we decline jurisdiction, it goes back and the ball's in your court to decide what to do to go forward. So I think there is a difference.
I think the question is, when you say abeyance, what do you mean by that?
I'm sorry?
When you say abeyance, you said a few minutes ago, what do you mean by that?
Well, that would have, what was being contemplated at that time would be something in the effect of a stay. But then, frankly, just like petitioner, the more that I looked at this issue and this question, and it seemed wrong to delay justice any longer. There's been, I'm told that 90% of the delay is attributed to defense motions, but there was a year-long delay that was attributed to court reporter failing to be able to get the transcripts ready, and that was from trial 1 until trial 2, where all parties agreed that transcripts would be very useful. So 1 year of this delay period was attributed to that. And it would be in contravention of what victims' rights sets out to do to ask for more delay.
But are you asking us to just stay resolution of the special action pending JD?
As you asked me here today, no, sir, I am not.
But that's what you said in the response. I have it right here. Ask this court to decline jurisdiction of the petition for special action, or if jurisdiction is taken, to hold the matter in abeyance until a similar issue is decided by the Arizona Supreme Court. Then you go on to talk about the JD case. I mean, I presume your response was taken after thoughtful deliberation, and that was the position you took. So I think this is a very unusual circumstance because of the procedural posture we all find ourselves in. If this matter is taken, we take this matter and we accept jurisdiction and we wait until JD case is decided, which will be in the fall, which is what you had asked for in your response. Your response to that is that this case needs to get moving along. Is that basically the reason why we shouldn't do that? That we need to get this case done?
We do.
Okay. If the Supreme Court, we're talking about ifs and ands and buts, but if the Supreme Court decides that the JD case is correctly decided and trial goes forward, tell me how the petitioner can show prejudice by not, after the case has been tried and assuming he's convicted, how could he ever show prejudice because he was not allowed to interview these witnesses here? How could he ever make that burden, thus trying to get a reversal on appeal? I just don't see how that could ever be reversed as a grounds for reversal.
And had there been questions posited by the petitioner that would give rise to a probability of prejudice, then I might be able to address that question. But frankly, the questions posited by petitioner were the hindsight 2020 kind of questions, the I wish I'd asked type of questions. And here there is no showing that there's been any infringement on the defendant's due process right or constitutional right, federal constitutional right. He's had an opportunity to see these people on the witness stand under oath and to vigorously cross-examine them. Just submitting a list of questions doesn't inform what rights are being violated. It's just a list of questions. In all
you would agree that it's a little bit more prejudicial, that there might be reasons why they would not want to go into what bad things were you predisposed to dislike this defendant? Have you heard about some bad things? Presumably they would not want to do that in front of the jury without having an idea of what the witness might say.
As with all cross-examination in every trial, risks and benefits.
If I could, I don't want to belabor it, but I read your response a little bit differently, maybe than Judge Norris did in terms of what you were asking. You were asking, we want you to decline jurisdiction is our first position. It's just if you decide that you want to take the case for whatever reason, in that event we want you to hold off until the JD decision is resolved.
That's correct.
On the re-indictment issue, what is your position, assuming they go back, if we decline jurisdiction and they go back and tell the judge, look, there was a re-indictment, one of the victims had already turned 18, what would the state's position be there as to interviews of those parents, of the parents of someone who had already turned 18 before the re-indictment?
Right. I'm glad you asked about that, because the process is that the state sought reindictment as new victims were coming forward during the pendency of the original set of charges. So there wasn't a dismissal reindictment as much as there was reindictment, then dismissal of the preceding indictment so that we could continue on now with more victims having come in. So there wasn't an extinguishing of any right, because the rights don't end until there is a final termination. And that reading seems quite consistent with
There wasn't a final termination, though, of the first indictment, that wasn't dismissed?
But it's a
without prejudice?
forgive me.
No, go ahead.
It's a continuum of the charge. The charge didn't go away. The charge remained the same.
Well, let's say the state just decides we're going to dismiss this without prejudice, and then a year later we just decide, okay, we're going to go forward again. Isn't there a break? Isn't this a new proceeding with the new indictment?
I wouldn't characterize it as a new proceeding. It is.
Would you characterize it as a new proceeding, for example, for purposes of speedy trial rights?
In that sense, the speedy trial provision does give the defendant that benefit. But your victim has remained the same.
Isn't it giving the state the benefit with you don't have to count the time previously? Is that, I'm sorry, I may be missing something. Assuming we've reindicted, you don't have to go to trial the next week just because you've had some delay. Doesn't that inure to the state's benefit if you've reindicted? The clock starts over. If you dismiss something without prejudice, we just do nothing. 5 years later, we get some more evidence. We start over. That 5 years doesn't count against the state for purposes of speedy trial, right?
The speedy trial piece, I think I understand your question, and yet...
I may not, but go ahead, sorry.
Perhaps I'm not certain that calm deliberation being one thing. But I think the crux of this would be that the continuum of the charge, that PG and RR, the two named victims that we're dealing with here today, that has continued, and it's the state's position in an uninterrupted way.
But if you could go to let's call it a hypothetical, a dismissal without prejudice, and 5 years later we file a new indictment. Would your position under that hypothetical be that the victim's parents can refuse an interview if the victim turned 18 2 years ago?
If the state of the law were Lucas, then that would give the jurist who's facing that question the opportunity to make a decision based upon all the factors listed in Lucas and giving effect to victims' rights in doing so, in the preserve and protect and the fairness, respect, and dignity piece of it.
But isn't the point of this is a very narrow provision, or very narrow aspect of victims' rights, that this only comes up because you have a parent who's exercising rights on behalf of the minor. And if let's just say if the charges hadn't been filed at all until if they're filed for the first time after the victim has turned 18, this right for the parents just doesn't exist. You would agree with that, correct?
I would not agree with that. And the example...
Well, let me give you that. So the hypothetical, just to be clear, we're just saying the victim was 10 at the time of the offense. The state doesn't bring charges until the victim is 25. That's the first time an indictment is filed. Under those circumstances, are you saying that the parents of the victim would be entitled to decline an interview?
Your Honor, what I'm saying is that there are situations, and the one that comes to mind is the one out of Cleveland, Ohio, Ariel Castro. He abducted 3 girls. He kept them, one for over a decade, as a sex slave. And then when that was found out, when that house was entered and they found that these 3 young girls had been taken by this man, are we really saying that we want the kind of rule that would say Well, you during your time with Mr. Castro, you reached the age of majority, and we're going to let you out. You haven't seen your parents in a decade, but you can't talk with your parents about what happened to you for fear that your parents will be subject to interview. I realize that's a parade of horribles that and it's almost
Well, but let me give you yet
But the
another
language of
hypothetical.
our statute,
Yeah, and just a different hypothetical. The victim is 19 years of age. I mean, certainly they want to talk to their parents. I mean, I think the language of our statute is that it's simply determined by when the proceedings commence. He's not arrested until after the victim is 19. I don't see the statute as providing that protection.
and the state's position has been and that the point of victimization is the point that you would want to look at to determine the age of this person at the time of victimization.
where in the language of the statute can you support that argument? That's we have to follow the law that the legislature gives us. That is what our oath requires us to do. Unless you could argue in your Castro situation that the victim was a vulnerable adult, so I think that's a possibility, but excluding that, where in the language of the statute could we do that?
In the language of the statute, well, let's, if we could, starting with the Constitution, the victim means a person against whom the criminal offense has been committed. It doesn't seem an unreasonable reading of that language to say victim means a person against whom the criminal offense has been committed, to say you were a victim at the time that this offense was committed against you.
We're discussing minors being basically represented by their parents, for lack of a better term. 134403C says if the victim is a minor.
Yes, Your Honor.
Right.
And so I would reflexively say that because where 4403 says if the victim is a minor, and if our Arizona Constitution says a victim is one against whom a crime has been committed, then look to the date of offense for the definition of when does one become a victim.
Just my disconnect, though, is the part of the statute that says if a parent is, and I apologize, I don't have it here in front of me, but if the parent is exercising rights on behalf of a minor victim, so that contemplates a situation where the victim needs someone else to exercise rights on their behalf. And so I'm still puzzled by, and just my simple hypothetical of this is, say the victim was 17 at the time, we don't find out about it for 5 years, we go to, the defendant's arrested at age 22. I don't read that language in the statute to say that the parents could come in and say, they don't need to exercise rights on behalf of the victim. The victim is now 25 years old. So I don't read that language as giving the parents a right to refuse to decline to be interviewed.
Under 134433G, where it talks about the section applying to the parent, one court has interpreted the as applies language to be liberally construed and to see that the parent has an independent right. I recognize what your hypothetical posits. But isn't the abuse of discretion standard the standard that exists to confront cases as they come before a trial court? There could be reasons why. There could be a stronger case made. We could talk about certainly the situation where something doesn't come to light 30, 40 years from now. At some point, we get to truly stretching the effect. But the case-by-case approach, grounded in the Constitution, liberally construed to protect victims' rights and to give them respect and dignity, seems consistent with the approach taken in Lucas.
And I apologize again for interrupting, but maybe just one other thought. Assuming assuming we were to decline jurisdiction and they went back and raised the issue, is there some, and you wanted to make that argument, there's nothing that prevents them procedurally from arguing that the law is we're entitled to interview this victim because of the reindictment. The state's position would not be it's too late for you to make that argument, and you would just be arguing that, well, we think the law is dependent on the age of the victim at the time of the offense.
They could make the argument, but again,
there isn't
this
a
is
ruling from the court that says it's too late now to file motions, presumably like the one they would file to say, look, there's a reindictment, we're entitled to now interview these parents.
the state would continue to oppose that. However,
On the merits, as opposed to it's too late to do that.
well,
And if you don't know, that's okay. I'm just curious if you know of something that would prevent them from doing that.
I don't know the answer to that. The biggest concern that the state has had here would be that the Lucas decision offers an opportunity for collateral litigation. And the question would then become, which questions are excluded from being asked, and which questions then become...
You mean the JD case?
I'm
Big
sorry,
case,
yes, forgive me. Yes, the JD case. Which questions are excluded, which questions become fair game? And then as that tracks through, you recognize that not only does the parent victim need to have counsel present to determine which questions to answer and ask, then the child victim needs counsel present to determine whether his or her rights are being infringed upon by the asking of the question. There's a lot of litigation now that would be surrounding that process and would further delay, and in the state's view, hamper and impede the implementation of victims' rights. And I see I'm out of time.
If you'd like to take a moment to wrap up, that's fine.
Your Honor, I think your questions have been penetrating, and I doubt that there's anything further I could offer.
Thank you very much.
I'm afraid I did not keep track of my time, and my nervousness, I did not keep track, so
Well,
I'm
you
hoping-
have 6 minutes and 45 seconds.
I don't think I'll take nearly that much time. I just wanted to answer a few of the questions that I don't think were answered a moment ago. You had a question about whether there was still time, I think, to file the motion that we talked about earlier in terms of when parents exercise their rights and the new indictment. The answer to that question is that there's basically a 20-day rule that us trial attorneys are usually required to file any substantive motions or evidentiary motions or pretrial motions other than motions in limine, motions. We're required to file them 20 days before the trial date. So I guess my understanding is, based on that rule, we would still have time to file such a motion. So it answers that question. I just wanted to say just very briefly about the delays, the issue of delays. This case has been pending a long time. The first time it was pending from 2000, from the 2000 original indictment, the state then dismissed it and re-indicted to add an additional victim. That caused quite a bit of delay. There were also some legal issues about. Again, the issues of interviews kept coming up over and over again, interviewing other witnesses, interviewing parents. It was constant since the beginning of this case. So there was time that was spent dealing with those issues. That's, again, back at the first original part of the case before the case was dismissed. When the case was dismissed following the hung jury, we had, as Ms. Kemper mentioned, quite a long delay occasioned by the court reporter that had. You really can't blame anyone for that, I don't think. And then there was an additional delay. At the same time, we were having problems getting the transcripts. Ms. Felmy, who's been a wonderful addition to our case, but that caused quite a bit of delay because she had to get up to speed and read. You can imagine by this time there's boxes and boxes that comprise this file.
I do want
this
to make
case.
sure you're being recorded.
Oh, sorry. Thank you, Judge. There are boxes. This case comes in boxes and boxes and boxes. I almost have an entire room devoted to this case. So Ms. Felmies had to read through all of that and become familiar with the case herself so that she could be effective. That's been a big delay, too.
Let me ask you a question.
Sure.
I have looked at the trial court record in the 2012 case, the current case, and I saw that the trial judge had stayed the matter. It's not clear to me what effect that would have on your trial schedule, which, as I understand, I think is for September the 15th.
I think that's correct.
I don't know if you can answer this. Is there something that you would know of that relates to the scheduling where trial on this matter is going to be pushed back to later in the fall because of the pendency of the special action and this stay that the judge has entered? Or is it still scheduled for trial for September the 15th?
It's scheduled for trial for the 15th, I think, but I don't know what, I have to say, this is the first time, I think this is the first time that I can recall in quite a while that I've had a trial judge stay a trial proceeding. So I'm not completely sure, and it's Judge Gates, I'm not sure exactly how Judge Gates is going to handle that part of this. So I wish I had an answer, but I don't really know.
But nothing has changed. That's the current state of the...
It's still set for that trial date, but I'm anticipating, Judge Gates is very reasonable, and I'm anticipating that if she doesn't have an answer to this question, this issue, that she's going to continue to stay it until she gets an answer. I think is what will happen. So that's all I had. I just wanted to answer some questions, and thank you very much for listening to us.
Let me ask one other question. The state filed a motion yesterday to redact the names of the individual victims. I confess, noted that in the petition. Do you have any objection to granting it? No. Okay. We'll issue an order on that. We may ask you, I'll have to think about how to handle this, we may ask you to file a substitute petition on this because those names should have been redacted. Okay. Nothing else? Well, thank you both for your argument today. We appreciate it very much. We'll take this matter under advisement and issue a decision in due course. Thank you.
Well, the interns were supposed to be